I'm Johannes Schmidt. Welcome to Divorce Schmidt Series 2. As it's been a couple of years since I last released an episode, it was important to launch this second series with something a bit special. So I've travelled to the Maldives for the purpose of producing some episodes on travel-related family law topics. Of course, I might incidentally undertake some leisure activities while I'm here as well. But in case the Commissioner for Taxation is watching, I booked this trip for the dominant purpose of producing these episodes to help with the income-producing aspects of my practice. In this episode, I'll be talking about how the Family Law Act impacts on parents wishing to travel overseas with their children, some considerations to take account of when drafting travel-related orders, and also some things to avoid when drafting those orders. You are probably aware that Part 7 of the Family Law Act relates to children. It's Division 6 of Part 7, which relates to parenting orders other than child maintenance orders. And Subdivision E of that division deals with restraints on taking or sending children outside of Australia. It's really important for both parties and lawyers to be really across the provisions of Sections 65Y through to Section 65ZAA, because breaches of those sections are an offence, and the penalty is imprisonment for 3 years. So they're quite important. In essence, what those sections provide is that if a child is subject to an extant parenting order, or an application for a parenting order has been made in relation to a child, it's an offence to take or send the child outside of Australia unless it's permitted by a court order or there is authenticated written consent of the other parties. So either the other parties to the parenting order or the other parties to the application. There are corresponding provisions which make it an offence to retain a child outside of Australia for longer than permitted by the order or the written consent, but they have an exception where the person retains the child because it's reasonably necessary to do so in order to prevent family violence. In my experience, it's incredibly common for both parties and lawyers to overlook the requirement that the written consent be authenticated. Authentication for this purpose is prescribed in Regulation 51 of the Family Law Regulations 2024, which in turn refers to the legislation at Commonwealth level related to statutory declarations. In essence, what is required is that someone who's authorised to take a statutory declaration endorses the written consent with two things. One, that they have taken reasonable steps to verify the identity of the person signing the consent, and two, that they've witnessed the signature. I don't think in 15 years of practice that I have ever actually seen an authenticated written consent prepared for travel. And I'm also not aware of anybody who's travelled based on a written consent which wasn't properly authenticated being prosecuted. But nevertheless, it's an important thing for lawyers to be aware of because, of course, we have firstly an obligation not to aid anyone in committing an offence, and even a technical breach of those provisions is an offence. But also, we've obviously got an obligation to give correct advice. So it's really important that lawyers are across this stuff. I want to turn now to parenting orders that provide for travel with children outside of Australia. It's important to draft travel-related orders clearly and precisely, both when drafting applications and when drafting consent orders. It's especially important for final orders. If final orders are in place and a parent wants to travel with a child beyond what those final orders provide for, they'll need, again, authenticated written consent or a further order of the court. And a further order will require a new application and will be subject to 65 DAAA requirements. And that applies even if they just want to travel for, say, 1 day longer than what the orders provide for. So it's really important to get this stuff right. In terms of travel periods, if it's an order for specific travel for one particular trip, for example, you're drafting an application and proceeding to allow travel on an interlocutory basis, be sure to be really precise with the start and end times because the travel will have to fall within those periods. So make sure you get really clear instructions on when the travel needs to occur, including transit times, travel time to the airport, and so forth. When you're drafting more general orders that permit travel during particular classes of times, again, make sure you actually get instructions to ensure that what you're drafting is sensible for the particular matter, for the particular case. So typically, the sort of orders that get drafted are permitting that either parent can travel with a child during their regular time during school holidays, as provided for elsewhere in the orders, or perhaps less restrictive during any time they've got the child in their care. Often it's common to include conditions on the travel. The most common one is no notice requirement. So for example, the orders might say that no later than 30 days the proposed start of the travelling parent has to provide the other parent with certain information like itineraries, flight details, contact details and the like. There might also be a requirement to provide proof of travel insurance and that sort of thing. You might also have restrictions on where the travel can occur. And the common ones there that I usually discuss with clients and often include in orders are designations by DFAT. So if DFAT says a particular location has a do not travel advisory or a reconsider travel advisory, that might be excluded. And the other one is restricting travel to non-Hague countries. But with the non-Hague issue, you've got to be really, really careful because a lot of the destinations that Australians regularly like to travel to aren't signatories to the Hague Convention. So for example, Indonesia is not a signatory. So if you prohibit non-Hague countries, then that family can't travel to Bali unless it's there's some other provision in the orders or there's other consent. I also like to include another order after the main travel order, which to the effect that, except as provided for in the travel order, the parties are restrained from taking the child or the children outside of Australia, except with prior written consent of the other party. And there's two reasons I like to include that order. The first one is technically redundant, and that's just to make it clear to the parties that, other than that, they need consent of the other parent. Now that's the position under the Act anyway, under those provisions I've already talked about, but it makes it a bit clearer for the clients. And the other reason is that the exception to that is where there's prior written consent. And it notably gets rid of that requirement for the consent to be authenticated. And the reason I like that, particularly for final orders, is it avoids the parties then having to go back to their lawyers or to find a JP to provide that written consent to ensure they're not technically committing an offence, particularly if it's for something small. So say, for example, the orders provide for travel during school holidays only, but the parties agree that the child can miss the first 2 days of the next term. That can then be just agreed in a WhatsApp message or an email or whatever the parties choose to do there, without having to see the lawyers or find a JP. And could also be for things like a party hasn't complied with a notice period. Say the requirement is that they have to give 30 days notice for the itinerary, but they're travelling because there's been a death in the family and they need to go to the funeral. So it covers those sorts of issues. The last thing I want to talk about is some things to avoid. I've got a real bugbear with a really common type of travel order that I see. And that is an order that basically sets out all the stuff that I've suggested setting out, but still makes it subject to agreement by the other party. Because that doesn't actually permit anything. It just sort of summarizes the stuff that they should be talking about to inform whether or not they'll agree. It leaves the parties no better off than just having no travel orders at all and just leaving it to section 65Y through to 65ZAA. So in my view, drafting those sorts of orders is both a waste of your time as a lawyer and a waste of your client's money in paying you to draft it. The other thing that you need to be careful to avoid is just slavishly following a precedent. Orders need to make sense for the particular family and in the context of the overall orders that are being drafted. A recent example I dealt with was a matter where orders were drafted on a final basis at a court hearing. So everybody was at court. It was done under a bit of time pressure because they were there for an interim hearing or a mention or something and decided to draft final consent orders there and then. And as best I could ascertain, those orders were drafted by the independent children's lawyer using that independent children's lawyer's usual precedents. And those orders included a travel provision very much in the way that I've recommended drafting it. It had the notice requirements, it had the restrictions and all that sort of stuff in it. And it said that the parties could travel at any time when the child is scheduled to regularly spend time with the party under the parenting orders. But what that provision failed to take account of was that in the circumstances of that particular case, the child, the only regular time specified in those orders for the child to spend with the father was 2 nights on 3 out of every 4 weekends. And the context there was the parties lived several hours apart. Somewhat unusually, those orders did not include any specific time during school holidays. That 3 out of 4 weekends just rolled all the way through the year. And the effect of that was that whilst there was, to the understanding of at least the father, an order that permitted him to travel, and he thought it meant he could, travel quite liberally through the holidays, what the orders actually did was they permitted him to travel for 2 nights and 3 weekends out of every 4. And of course, given the distance from Australia to pretty much anywhere except New Zealand, or perhaps the southern parts of Indonesia or PNG or places like that, you can't really do international travel in 2 nights. It's not like you live on the border of Germany and France, you're just hopping across the border. So those orders were really quite useless. And in that particular case, he wanted to travel overseas to see family. Both the parents and the child were born overseas, but he couldn't do it. He had to. The mother wouldn't agree. He had to make an application to the court, and it was listed for a 65D AAA threshold hearing. So you need to be really, really careful with how you draft these orders, and don't look at the orders in isolation for travel. Look at them in the context of the overall case and the overall orders. I'm Johannes Schmidt. Thank you for listening. I hope that this discussion has been of use to you. If you'd like to be notified as I release further episodes of Divorce Schmidt, please follow me on your preferred social media platform, subscribe on YouTube, or subscribe on your favourite podcast platform.